Tēnā koutou. Mai e te tipua, mai e te tapitu, mai e te kawiariki, mai e tapitu ki a koe e rongo. E rongo whakaire ki ronga, ki ke tēnei hui. Haumi hui e tā ki e. Tēnā koutou. Tēnā koutou e puri mai ki tēnei tō tātou nei noho tahi kōrero tahi. Te ahi ahi nei, tēnei mātou e mihi ana ki a koutou nei mai hara mai, whakapuri mai, whakahono mai. Whakahono mai rungi nā āhua tango te wā, nā mate o rātou ki a rātou, tātou no ki a tātou, mauri ore ki a tātou. Ko tēnei te mana mātāpuna matatapu e mihi ana ki a koutou, nei mai, hara mai, whakatau mai. Whakatau mai i runga tunu i te tono tō tātou nei kumihana, John Edwards, raua ko tō tātou nei kumihana tuarua, Liz MacPherson, tēnei a hau nei, PJ Devonshire, e mihi ana ki a koutou, nei mai, hara mai, whakatau mai. Kia ora tātou, PJ Devonshire, and on behalf of the Indigenous people of Aotearoa, on behalf of my ancestors and the language of my ancestors, we welcome you to this session today. We welcome you to the Privacy Commission. Welcome you on behalf of the Privacy Commissioner, John Edwards, and the Deputy Commissioner, Liz MacPherson, nei mai, hara mai, whakatau mai, kia ora tātou.
Kia ora tātou katoa. It's my privilege and pleasure to welcome you today. My name is Liz MacPherson. I am Deputy Commissioner here at the Office of the Privacy Commissioner, and today is our final Privacy Live for 2021. And in the hot seat for his very last Privacy Live is the departing Commissioner, John Edwards. It's my very great pleasure to be able to put my questions and your questions to him today. Now, just a little bit about how this session will work. We do have Slido available for those of you who are watching. The way to get access to this is to go to the link in the comments section of the section you're watching in. Click on the link and you'll get to Slido. You can put your questions in there for John, and what we ask you to do is upvote them. We'll take the ones that are most popular, they'll float to the top, and that way you get to put John on the hot seat as well. So with that, John, it's fantastic to have this opportunity to put some questions to you. And the one I wanted to start with was, when you became Privacy Commissioner almost 8 years ago now, you said that one of your aims was to make privacy easy. What did you mean by that? And do you think you've achieved it?
Sure, kia ora. Thank you, Liz. Kia ora, PJ. Thanks for that karakia and introduction, and thanks to everyone dialing in. And I will answer that, but before I do, I want to say congratulations to you on your appointment as New Zealand's first Deputy Privacy Commissioner, and it just means so much to me to be confident that there's a continuity and a stability for the office, and that our mission continues. So really pleased about that. Yeah, I remember the first appearance I had before a select committee was to defend the annual report of the previous year's operation of the Privacy Commissioner, and it was on the third day of my time in the office. And I don't think anybody mentioned to me that I would be invited to give opening remarks at the select committee. And they said, well, what are you going to do? And I kind of stumbled around a bit, but I said, well, I think, what I really want to do is make privacy easy. And I said that there was 3 parts to that. I wanted to make privacy easy for agencies to comply with. I wanted it to be easy for consumers to access privacy-friendly options. And I wanted easy access to remedies for people when things went wrong. And I think that we have achieved that. I see a much greater awareness of privacy around us in both government and in commerce. I see businesses valuing privacy and consumers demanding and receiving privacy. I see much more transparency around the kind of information transactions that we all enter into every day. I mean, there's been a lot of ways that we've achieved that, I think, as a team here. But when I took on the job, we provided training to people, for example. And we did that once a month. We'd have 20 people in a room and we'd deliver a workshop to them. So over a year, we'd deliver training to about 200 people. Well, we've since developed e-learning. It's free, it's online, it's on our website, and there's a whole lot of different modules. And in the last 6 or 7 years, there's been over about 150,000 people have gone through that. So, you know, that's one of the ways that that we've made privacy easy. But there's a whole bunch of other ways that the team has rallied around and really thought about how to deliver our services. So we've got, for example, you know, online lodging of complaints. We've got a tool called About Me, by which people can make their own information privacy requests and fire them to the agency, and the agency gets that with advice and information from us about, you know, what they have to do with that request. And you know, every time we've had these ideas, there's been a whole team has rallied around. You know, when we became aware last year that there was mandatory breach notification coming in, we had a cross-office team designing a reporting interface. And you know, I thought it would be quite easy. What we want is a web form, but you know, these things are always far more complicated. And we collaborated with industry. We looked at this problem from all sides and came up with a solution that tried to take as much of the compliance cost out of this new obligation and delivered targeted advice. So yeah, I think we have achieved in that mission, but you know, it's an ongoing mission. I think we have to keep trying to improve it, make things easier.
Never-ending mission, yeah. So one of the things that I know, because I was here at the time, that you put a lot of effort into over a good number of years in the role, was law reform and really updating the Privacy Act, which was 1993. We got the new Act in almost a Christmas present in 2020. That was a big year. We're now we are a year into the new Privacy Act. What do you think it's meant for the way OPC does things?
It gave us an opportunity, I think, to really reimagine what our role in the economy is 27 years after this first Privacy Act arrived. You know, for all of that time, we were really significantly complaints driven. A significant amount of our business and investment was on these point-to-point matters that arose between an individual and an agency. And it always occurred to me that that was not a particularly efficient way to change behaviors. I mean, it is really important. It remains a core part of our business to ensure that people have access to remedies. But I do think that it was important to think about what are the incentives that industry responds to in things? How do we, again, make it easy, make compliance easy? What does our regulatory pyramid look like? You know, what tools do we have? So with the new Act coming in, we had a couple of choices to make. I think it would have been pretty easy just to say, you know, the changes are pretty cosmetic to a large extent. We can just bolt these on to our existing infrastructure and continue doing things the way that we've been doing them. And, you know, that would have been defensible. We've done things pretty well, I think, over the history of the office. But, you know, those small changes did represent an opportunity. One example is the enforcement threshold, for example. Under the Privacy Act 1993, anyone who wanted to bring something to us, a complaint and access remedies and the enforcement mechanisms, had to say, well, this agency did this thing and it was a breach of one of the information privacy principles. And it caused me harm or caused me significant humiliation, significant injury to feelings. So that's quite a high threshold. You know, so we were getting complaints, you know, about ad tech, for example. Someone would come and say, I didn't know that I was being tracked. And we'd have to say, well, okay, that may be a breach. But how, you know, how hurt were you? because being irked or annoyed, it doesn't get to that threshold of invoking the regulatory powers. Under the Privacy Act 2020, we have the ability to issue compliance notices, which are an instrument, a regulatory instrument that carries sanctions. So we can go out and look for non-compliance. And the significant difference is that that harm threshold is not there as a legal requirement. It's a matter that we need to take into account. How much harm does this cause? But we can take it into account in aggregate, for example. We can say, okay, it hasn't harmed this person, but if you take the annoyance across the whole economy, that reaches a threshold that warrants our intervention as a regulator. So in order to respond to that, we've actually set up a whole new team. We've got, as you know, the compliance and enforcement team, which is able to go out and look for non-compliance. And they operate under a compliance and regulatory action framework that we've developed, which gives them some instruction about how we allocate our scarce regulatory resources. And that, I think, is starting to really work effectively. We've been able to ring fence some of our extra resource and focus on insights and strategy. So we are more and more, I think, able to be the architects of our own destiny. We can look at our input data, we can look across the economy, we can look to other regulators and to other jurisdictions and say, well, where should we apply our discretionary capacity in a way that's going to be most effective for most New Zealanders? So, you know, I do think in the last year, we've made the most of those opportunities. We've got a way to go. We've bedded it, we've started to bed it in. These are habits which we've had to develop. I would like to have seen more compliance notices, for example.
Falling like autumn leaves.
Yeah, right. But again, you know, these things, you can't just snap your fingers and change a culture or establish business processes. It's one thing to have an idea, but you need a team of people around you with the skills to execute. And that's what we've done. We've issued compliance notices. We've got teams of people enthusiastic about this, about making a difference for New Zealanders. And so I'm really excited, and I think I'm leaving at a time where there's still enormous opportunities to capitalize on some of those changes.
Actually, one of the, you're talking about the difference between a complaints-driven approach and a more of a systemic or economy-wide approach. And I guess the rental sector work that we engaged in is an example of that.
Yeah, it is. It really is. Because again, it's an area where there's a power imbalance, where there is a fairly consistent and constant stream of intelligence to us, which implies that people in the tenancy market are disempowered, that landlords are from time to time abusing their position of power, over collecting information, being really intrusive, and that has been going unchecked. And again, when we get a call on a Monday morning from someone who says, you should see this form I was asked to sign on Saturday when I went to look at a flat, it just made me feel really depersonalized or humiliated or disempowered. You know, in the past, we might have said, well, what did you do? They'll say, well, we went and looked at the flat anyway, because we felt we had to. There's very little that we could have done with that. But what we've decided to do was to recognize the aggregated impact of that across all the Saturdays up and down the country, and say, well, that's an area that warrants intervention. And again, it's not just a question of sitting down and writing out what we think the law should be. We've had a team that's engaged with, right across the office, has engaged with that residential tenancy sector, talked to property managers, talked to landlords, talked to commercial operators and tenants representative groups. So we've had inputs from our policy team, inputs from our comms team who've drafted materials and made it really accessible. The complaints team has investigations and dispute resolution have input, the real stories that we get through our inquiries line and the like. And we've come up with something that makes a practical difference in people's lives. And it's sort of passed right through all those parts of the office, and it's now sitting with compliance and enforcement. So we can say now to those landlords and bad actors, if there was uncertainty before, now there isn't. We've put our money down. We've said what the rules are, and you don't have any excuse now but to do the right thing. And we're coming for you if you don't.
One of the things that I've noticed since I've been here at the Office of the Privacy Commissioner is that privacy is in the news pretty much every day. In fact, there's more that goes on here than I ever anticipated before I joined the organisation. In the news today is the second judicial review decision on the whānau ora commissioning agency and the Ministry of Health conversation about access over the by the commissioning agency to data about unvaccinated Māori in order to improve vaccination rates. It's a really interesting case. It's got a lot of brought a lot of interest to the issue of privacy. Now, the Privacy Commissioner you decided to intervene in both of these cases, the first and the second one. Why did you intervene?
We've intervened in a number of cases, more cases, I think, during my tenure than previously. Intervention means, there's a court case with a plaintiff and a respondent, or an applicant and a respondent, plaintiff, defendant, whatever. And a third party, who's a nosy Parker, says, we've got something to say about this. And, there have been times in the past where privacy matters have got to the courts, and the parties are not necessarily motivated to put all the information about how we see the law working before the court. And there have been times where, as a result, we've had decisions which have been challenging for us in terms of the principal agency responsible for implementing the law on a day-to-day basis. So where a matter of public interest arises in a court case that involves privacy, I've been very willing to apply to the court for permission to make submissions. And we did that actually in the US Supreme Court in the case of Microsoft and the Department of Justice. That was ultimately settled, and so the case wasn't heard. But we've intervened in one of Kim.com's pieces of litigation. We intervened in the Supreme Court when it heard a case about the relationship between privacy, search and surveillance, evidence, and the New Zealand Bill of Rights Act. That was a case called Ulsford. And in this case that you're mentioning, the whānau ora commissioning agency and the Ministry of Health, we thought that it was really important to give the court a neutral understanding of how we see the law that we are obliged to implement operates. And I think the court was appreciative of that. It is a really fascinating case. And I think the court, in the brief time we've had to read it, the decision only came out last night, has done a really good job of setting out the scheme of the Privacy Act, that it is, it's not a simple matter of, should information be given out or should it be withheld? It's the court quotes submissions that we made. The Privacy Act as a how-to, not a don't do. And, I think that's quite compelling. And it really gets the nuance that the Privacy Act operates as a manual for doing information sharing. One of the really interesting points I think that the court had to address here was that all the parties agreed that the conditions under which the ministry could release the information under the Health Information Privacy Code existed. So what that means is both the ministry and WACA agreed that the disclosure of the information was necessary to avoid or to remedy a serious threat to public health. That meant that the ministry could disclose the information if it wanted to, but it still had a discretion. So it didn't have to. But the point that the court has had to consider is, if it gets to that point, if all the parties agree that doing this and providing this information is necessary to avoid a serious threat, maybe there's actually a duty in there somewhere to do that, to make that disclosure of personal information. So it is fascinating, and it is also really a helpful decision, I think, for us as we begin the other journey, which I've bequeathed to you and my successor, of how we incorporate Te Ao Māori in our administration of the Privacy Act, and what role tikanga has. And I was interested to read in the decision that came out last night from Justice Quinn that it is well settled in New Zealand common law that tikanga is part of New Zealand common law. What does that mean in the day-to-day administration of the Privacy Act? That's a great challenge, I think.
It is a fantastic challenge, and particularly, as you say, when we as an organisation are looking at what is the Te Ao Māori lens for privacy, what does that mean? And some of the challenges around individual versus collective aspects of privacy. So fantastic to have it come out today. There's a lot. I mean, I really encourage anyone who's listening to this to have a read of that decision. There's a lot to unpack there. So we've got a few questions coming in for you, John. One of them, given that we've just been talking about the Privacy Act, is what would you like to see as improvements or amendments to New Zealand's privacy law?
I guess, I mean, I think I need to put in context, as a statutory officer, I and you are obliged to deliver on the will of Parliament. And what we see in the Privacy Act 2020 is the Parliament's expression of the balance that is best suited for our community in how we have data protection or privacy in New Zealand law. Many people who are on the call will know that as that bill went through Parliament, I did what any citizen is entitled to do and what a statutory officer is obliged to do, and made submissions and representations, and we had a wish list. We didn't get it. So, we moved from advocacy to implementation. So it's well known that I sought powers of sanction more closely aligned to those that my colleagues in in Europe and Great Britain have, which is significant powers to fine. We didn't get those. And I'm now, reconciled to that. So I'm not going cap in hand to the Minister of Justice and say, revisit this decision. I think that would be bad form. But the Minister did say that he was prepared to keep privacy law reform as an ongoing matter. And I think that that's really important and realistic, because as technology and society changes, the law has to be prepared to change with it. We've seen one of the areas that was not brought up to that GDPR standard in New Zealand, for example, was the right to algorithmic transparency. And as AI and algorithms start to make greater inroads into our daily lives, the need for people to be able to open the box and see why a decision was made, to appeal to a human, is really important. And you and I, when you were government statistician and I was Privacy Commissioner, we came together to create some standards around that. And we created the algorithm charter, which has some influence, I think, across the public sector anyway, and imposes some sort of standards of responsible conduct. So there's that, there's the conversation around the right to be forgotten and what that means. And that's a more nuanced and complex conversation than we had time for, I think, as the bill was going through the House. And I was kind of chastised by one of the parties in the select committee for even raising it, because I think they thought I was advocating for some regime by which aspirant politicians could bury their shady past and put it beyond commentary. Whereas, you know, if you frame it in terms of, well, wouldn't you want your daughter to have the right to insist that a platform takes down an intimate image that a former boyfriend has posted online? You know, then you have a different kind of conversation. If you look at it in the light of the ransomware attack, data exfiltration and subsequent dumping of highly sensitive personal information on the dark web that we saw in the Waikato DHB, you could see a right to be forgotten there about, you know, a right to be delinked, to be de-indexed, to say that someone can insist that websites do not make it easy to find that kind of data. So I think there are still plenty of areas for law reform.
I'm just looking at some of the other questions we've got coming in for you, John, and one that's been upvoted is focused on, I guess, people out there who are working in agencies looking to meet privacy obligations, and it says, what are the main obstacles, in your opinion or experience, to New Zealand organisations understanding and meeting their privacy obligations?
Yeah, that's a really interesting question. I think it's probably getting attention at that C-suite and governance level. I think for a long time, privacy was regarded as a mere compliance issue and was treated the same as a myriad of other regulatory compliance matters that organizations had to face. Increasingly, it's been seen now as a condition precedent that, you know, that this has to be baked into your value set as an agency in order to succeed and win the trust and confidence of your customers. So it's getting that understanding at the governance level, and then it's following that up with resources to push that sort of cultural value out through the organization, I think.
We've often talked about it as being about leadership, haven't we? And you know, to what extent do your risk and audit committees think about privacy as an issue? And I would have thought that COVID has really brought that to the fore, how critically important the use of personal information can be to save lives, and the importance of trust and confidence in being able to use that. So yes.
Absolutely. Yeah, I mean, COVID has changed so many things. And, you know, if you had asked me at the beginning of last year, imagine a pandemic came, what would be the privacy issues? I wouldn't have begun to imagine the range of stuff that we would have been consumed with.
Which brings me to another question. What was the most memorable issue you have dealt with as your time as Privacy Commissioner?
There's been lots, and they range from individuals expressing their deep gratitude to the investigators and the investigation dispute resolution team for the profound impact just the human act of listening has had on them. You know, I find those very moving and validating. Through to the sort of more macro matters, such as the inquiry that we did into the Ministry of Social Development, when it changed contractual terms for NGOs delivering social services to say, for every person who accesses your service, you have to tell us their name, their date of birth, their names of their children, and a bunch of other things. And there was, this was just sort of unilaterally delivered to these agencies in relation to about $300 million of social funding. And several came to us and said, this is really going to undermine our trust relationship with these people who are among the most vulnerable in society. And the team that investigated this and looked into it found the same story again and again, that, for example, if if we really want a woman who's experienced years of abuse and domestic violence to finally take that step, to gather up her children and reach out for help, and to go to an agency that doesn't judge, that just provides shelter and safety, is the first thing you want her to see a form that she has to fill in with a note at the top saying, this is going to the Ministry of Social Development. And the answer to that has to be no, right? And after we did that inquiry, and the report was actually tabled in Parliament, and there was a snap debate on it, and every person who spoke, whether they were from the government side or the opposition, spoke in favour of our report and how important it was. The policy was abandoned, and for, I don't know, years afterwards, wherever I would go in the country, there would be someone would come up to me from the Tauranga Budget Advice Service or the Women's Refuge in Central Otago or whatever, and say, thank you so much for doing that work, because it really made a difference to those organisations and their viability and their ability to help, as I say, some of the most vulnerable in the community. So, those are some moments that stick out for me. It's the ones that really have an impact on the individuals that we're there to serve.
I think, again, having been here for 20 months now, it's brought home to me again just how critical it is that privacy is ultimately about the person, isn't it? He tangata, he tangata, he tangata.
Yep.
And keeping that focus. We often have that conversation with privacy officers, and people who are facing a privacy breach. Put the individual at the centre of what you're doing, and you'll almost make the right decision.
Yeah, I think so. And we have in New Zealand a sort of risk-based framework, right? There's a law of general application. There's uncertainty in it. Agencies have to make judgments every day, and I think I have been criticised in the past for some of the allocative decisions that we're making, but that risk-based framework really informs my assessment of priorities as well. And I'm not going to allocate the resources of this office to something which isn't causing anyone any harm, if that means taking resources away from people who might well be in need of the support of the law.
There are a few other questions that are drifting in here. But one of the things I did want to, and one of the things is a question that is actually of a lot of interest to me, given that I'm going to be looking after the organisation while the recruitment process is continuing, and that is, what's your advice for the next Privacy Commissioner? And it seems to be top of the list. So,
yeah, okay. Well, I think we've covered it really. It's maintaining that sense of the importance of the individual, the humans who are affected. For years people were talking about big data, and I kept going into these conversations and saying, big data is made of little data. There are people there that you're making decisions about. So it's that ability, I think, to recognize the human influence, which I think is empathy, really. What else? I do think it's important to choose your battles. I've thought about this idea of influence capital, right? So you build it up. And I don't think there's anything wrong with calling out good practice. It's really important. So if we see a government agency doing something really well, then we should say so. We should say, look, this is a model, and we're really pleased to see that this bill or this policy proposal takes really good account of privacy. And so, you pass out plaudits and don't sort of chase every passing car. That way, when you do have to speak up, people take notice. I mean, there've been a couple of occasions in the last 7 years where we've engaged and tried to help at that policy level, for example, in the way that we've done dozens and dozens of times. And the agency has said, or a minister has said, yeah, we hear you, but we disagree. And we just have to say, okay, well, that's your role. This is not personal. But I think it's important that the Prime Minister knows what the Privacy Commissioner thinks about this. And we've prepared a report. We've given it to ministers in draft to say, have we accurately reflected your proposal and its rationale? And on a number of occasions, that's had the effect of stopping a proposal that we think is disproportionate or that could be really harmful without delivering the expected benefit.
That's very useful advice. Thank you, John. I've got another question here, which seems to have quite a number of votes, which is around the use of cloud computing. Are you concerned about the increased use of cloud computing in consideration of data sovereignty? This goes to this sort of localization issue that we've been discussing.
Yeah, and I have to say no, because otherwise I'd be a hypocrite, because our infrastructure here at the Office of the Privacy Commissioner sits on Microsoft Azure servers in Sydney. So, I think storage and processing is now a global commodity. And as a steward of, public funds, I have an obligation to spend those in the most prudent way possible. And if I can access cloud services in a way that gives me confidence that it's going to be secure, gives me cost-efficient access, then I think that I should do so. The other thing to remember, I think, about cloud storage is the scale at which it occurs, which means that, for a small office like ours, it's really difficult to access top-level security, and I can't compete with a Microsoft, for example, in terms of anticipating threats and getting ahead of them. So I'm probably disappointing the questioner there, but I'm not concerned. I am concerned about the conditions in which cloud services are provided and the importance of transparency. So, there's still an obligation of due diligence when you engage with those services. And sometimes it's actually quite difficult to know where that data is going and whether your service provider is monetizing it in some way or is simply providing you with a service that doesn't involve them getting to see or use that data.
In terms of, this takes us on to thinking about some of the big global platforms and platforms here in New Zealand that are aggregating data. Is that a concern for you? And what role do you think, working with colleagues, you're going to be our colleague, plays in this from a sort of cross-border perspective?
It's really important. This is one of the biggest challenges that we face as a regulator, but as a nation, right? There was a paper that was presented last week at the Asia Pacific Privacy Authorities, APA, and it was presented by, I think in the open session, so I can say it, the Centre for Information Policy Leadership, I think they're called CIPL. And one of the recommendations they had, and this is an industry-funded sort of think tank / lobby group, one of the issues they had was that regulators should be more consistent. And I actually called them out and said, why? Why should we be consistent with each other if we are acting in a way that reflects our community's values? That consistency is something that has a real commercial value for an organization which is operating in 120 different jurisdictions and things, but they need to respond to the communities in which they are working. So there are, though, issues of scale which affect our ability here in New Zealand to insist on those values. It's just, it's just the real, the economic reality of taking a $1 trillion company through the legal process to enforce something which, on its own merits might not particularly warrant it. This is the situation we had in 2018 when one of these platforms denied that New Zealand law applied to it, even though it was collecting information about millions of New Zealanders and making a load of money here. But you can see the cost of that's borne by an organisation like the Commerce Commission, for example, when they took on Viagogo. Viagogo is a Swiss-based company that sells tickets to gigs and things. Sometimes they exist and sometimes they don't. And the Commerce Commission found that they were acting in breach of New Zealand's consumer protection laws. But that required a trip all the way to the Court of Appeal. And I don't know how much it cost, but our budget here at OPC is only about 7 million, and we could easily burn through that for very little gain taking on one of those companies. So, going to an organisation like the ICO in the UK, working with colleagues in other jurisdictions is the only way to sort of try and get the effective scale that we need to change some of those behaviours.
Thinking back over the last almost 8 years now, are there any things that you would do differently?
No, I've been perfect. There must be dozens of them. One of the things that I've been reluctant to do or slow to do is use the regulatory power under the Privacy Act. And I think that perhaps some agencies would have appreciated if we had done more in that. So, codes of practice is a law-making power that we have that can change and tweak the law. The thing is, when I came into the job in 2014, the decision had kind of already been made that was not working as a model to get the sort of flexibility that industry and government were hoping from the Privacy Act. And so this new mechanism of approved information sharing agreements, ACEs, was put in place. And I oriented the office to supporting that and trying to support organisations to get those, and they've struggled. They've still struggled. So, maybe we need to go back to codes and have a look at those. So, yeah, I mean, there's all sorts of things that.
Certainly, the Health Information Privacy Code is one that people rely on hugely.
Yeah, yeah, it has been, and it's great credit to its drafter, Les Stewart, who was an assistant commissioner here for many years, and was a real innovator in terms of privacy law internationally.
And then thinking about some of the, the world has changed a bit since you came into the role in 2014. What do you think are some of the biggest challenges facing this office going forward?
I do think that it is a big challenge to maintain a balance between assisting organisations to achieve their objectives within the law and being a more assertive regulator and enforcer behind that. That's something that, it's a constant tension that you've got to keep mindful of. We've seen examples, I think, of regulatory failure where in their efforts to make it easy to comply, to help agencies, we've seen a reluctance to use some of the sanctions and coercive tools that Parliament has given us. So it's just something I think that we need to keep mindful of and keep watching.
From a privacy perspective generally, in terms of our future challenges, what do you think are the big things coming down the track? We've talked about quite a number of them.
Yeah, I mean, there is the relative size that we have and our ability to regulate the kinds of technologies that come into the country, for example. We're seeing a ubiquity of sort of, retail digital devices that facilitate really intrusive practices like facial recognition technologies and the like. Advances in AI are going to transform, I think, almost every aspect of our lives. And it's being, it's knowing the temperature at which the frog is going to start to cook, and getting in there and doing something, because these things change gradually over time, and you've got to sort of be alive to that.
I'm just looking at some of the other questions here, John, and seeing whether there's any others that you might like to take.
Yeah, well, what have we got here? How do we think that IPP 12 has worked over the past year? It's interesting, because this is another, I think, international preoccupation which we don't pay much attention to in New Zealand, and I think we're pretty lucky because we have that adequacy status in the EU. And we are regarded as a pretty good country in terms of privacy protections. I should just say, because maybe not everybody knows. Last year we got a new privacy principle, which imposes obligations on any agency that's exporting data. So if you're sending personal information to another agency in another country, you now have obligations to satisfy yourself that it will be protected by comparable safeguards. So that either involves doing your own due diligence, which is a pretty significant ask, or it involves the creation of approved lists and prescribed countries, which are set out in regulation. We haven't seen any of those yet. That'll be one of the things that you'll have to do next year, I think. Or that you send the information with safeguards that the receiving party accepts. And we developed standard contractual clauses which would achieve that. So a little bit of the New Zealand Privacy Act travels with data. But in answer to the question, how is it working? To be honest, I'm not sure that New Zealand businesses are taking that much notice of it. I mean, we don't see large numbers of downloads of our contractual clauses, for example. We've seen a bit of pushback and criticism that they are complicated, that they are. So yeah, I don't know. I don't know how it's working, or whether it's a law that looks better on paper than it works in practice.
Something to talk to the users about.
I think that's right.
Again, this is one of those areas where we tried to do something that might make life a little easier, but we need to test and see whether it actually worked.
Yeah, I think so. And I'm also interested in the cost of it. Are people going and drafting their own agreements? Are they really studying the laws of these destination countries, or are they just sort of firing the stuff off in blissful ignorance of the obligation?
Okay. What else have we got here? Got one for you, which I think you've already basically touched on, potentially touched on. The point is, the departing UK Information Commissioner has warned against weakening protections with regard to automated processing, for example, the right to have human review. We talked about this a little bit in the context of algorithm charters, but did you want to take that one any further?
Yeah, well, the UK is in a process of reviewing its data protection law post-Brexit, and with 3 years of GDPR under its belt. And they put out a discussion paper, and the ICO has swung in to really advocate for the maintenance of the independence of that office, and I very much support that position, but also to warn against getting rid of regulatory measures that are there to really can have an influence and protect people. And I think that one is an important one. And as you say, it's one that we've addressed here in a more administrative way by getting that undertaking from government that they'll comply with an algorithm charter.
Yeah.
But yeah. So I'm very much looking forward to participating in that review process in the UK and providing advice to government about some of the implications of those proposals.
Well, Well, John, we're coming towards the end of Privacy Live, your very last Privacy Live here in New Zealand. As I said before, it's been a huge privilege for me to be in this seat asking you the questions, and also a real privilege for me to pick up from you and to look after the organisation over this next period of time while a search for your replacement is undertaken. And I guess the other thing that we can think about here in New Zealand is that we're not losing a Privacy Commissioner, we're gaining a friend across in the UK, and a friend who's got a big checkbook. So, you know, so we'll be looking to you across the other side of the globe, and I'm looking forward to engaging with you then. But here's something I didn't warn you about, but I'm going to throw to you. When you spoke in front of the Select Committee in the UK, when you were being scrutinised for your appointment, you threw them a Fleetwood Mac line, and said that your advice to the UK was that they should go their own way. Do you have a line for us to leave us as your parting gift?
Don't stop thinking about tomorrow.
Ngā mihi to John, and thank you all for tuning in to this very last Privacy Live for 2021. It's been a big year. It's fantastic to have this opportunity to farewell John in this way and to record his reflections. So ngā mihi nui from me, and mā te wā.
And I just want to say also thank you to everybody in the audience for tuning in. We've got a fantastic privacy community in New Zealand. It's been very supportive of this office. I've always had the support of ministers and members of parliament, and I've very much appreciated that. But behind me in the office here, there's a team of people who are utterly and entirely dedicated to the best interests and welfare of all New Zealanders, and they are tireless. And they undertake this work sometimes at significant cost to themselves. It can be stressful and draining, but they love it and they do it for you. And I give them my full respect. And I know that this office will continue to be strong because of them. So thank you to everybody.
So again, ngā mihi nui from both of us. And I'm going to pass over to PJ now for karakia.
Kia ora koutou. Again, thank you all for joining in to this Privacy Live session, the last one with John, and we'll wish him well and wish you well on your journey to the place, to the descendants of the Treaty of Waitangi, I might add. And so we look forward to hearing about your travels over there. Pea anō i te whānau, tēnei mihi ana ki a koutou ki ko mātou tonu tēnei, te mana mātāpuna matatapu, ko mātou ko tō tātanei kumihana, tō tātanei kumihana tuarua, mihi ana ki a koutou tēnei wā, māku I whakakapi I tēnei o nā hui. Engari, he mihi o te mirikiri himiti ki a koutou, Merry Christmas to you all, māku I whakakapi. Ai te manaki tangota wahi, nā ro ki runga ki tēnā o tātou. Kia māhe te hua mā kihi, kia toi te kupu, kia toi te mana, kia toi te aroha, haumie hui e, tā ki e, tēnā koutou.